Tim Sandifer is in the studio with us. He's the principal attorney with the Pacific Legal Foundation, a conservative, relatively activist group of legal beagles. PacificLegal.org is the website. Tim, welcome to the program.
I appreciate you having me back.
Thanks for joining us. You guys are challenging Obamacare in the courts. You're trying to get it before the Supreme Court. Right. And the basis of the challenge, I find this really interesting, the origination clause. The Constitution says that any legislation that has to do with raising money or spending money, taxes or spending, has to originate in the House of Representatives.
Raising money, yes. Spending bills don't have to originate in the House, just bills for raising revenue.
Just for taxation.
That's right.
And so what has been going on since, I believe, since the 50s, maybe before that, is that if the Senate wants to start legislation, they'll take some old House bill that never went anywhere, you know, renaming a post office or something. They'll take that particular House resolution, H.R. 238 or whatever, strip all the contents out of it, fill it with something else, and then send it off to the House as if it originated in the House. And this is how they did Obamacare.
It's actually older than that in one sense. In one sense, the idea of the Senate amending a bill by striking its entire contents and replacing it with other contents is, you know, hundreds of years old. What is a relatively new thing, and I'm not familiar with any instance of it happening until the 20th century, is for the Senate to take a bill and insert revenue-raising measures, because there's nothing unconstitutional with the Senate taking a House bill on about a post office and replacing it with a bill about, I don't know, military uniforms or something like that. Right. But the Constitution specifically says that tax bills shouldn't be originated in the House, or I mean in the Senate, and we've looked, and I haven't found any case except for the TEFRA cases in the 1980s. Remember the tax bill there, in which the Senate has taken a House bill and replaced it with a Senate-originated tax measure.
The TEFRA case, I don't know what that is. This was during the Reagan administration?
That's right. And remember, there was a very large tax bill that went through in the 80s called TEFRA, that what happened was that the House had passed a bill that would have cut taxes, and the Senate took that and amended it by changing it to a bill that raised taxes instead. So even there, it's a little bit different than what happened here, because there it was still a tax-related bill. Right.
So is the core of your assertion that outside of that TEFRA bill, that this is really the first time this has ever happened, and therefore it should be struck down? Or just, you know, it should be struck down because whether it's been going on for 100 years or not, it's wrong? Well,
a little of both. I mean,
it's unconstitutional.
Part of the problem is that it's hard to find precise records about everything that Congress has done in this. So although we've looked, we haven't found previous instances. That's not to say there isn't at least something out there, but the Supreme Court has never pronounced on this particular kind of procedure, where this what we call gut and replace procedure. The Supreme Court has only heard a few cases involving the origination clause in its history. And the one case that's particularly important is a case from the 1910s where the court said, as long as the Senate amendment is germane to the subject of the original House bill, then it's okay. And what the court said in our case is they threw out that germaneness test. They said that rule doesn't really apply.
What was the original House bill that was sent over to the Senate that was turned into Obamacare?
It was a 6-page bill that would have done a couple things. It would have given tax credits to veterans to buy their first homes, and it would have changed the interest rate that corporations have to pay if they're paying back taxes on the installment plan. So it was a little 6-page bill.
So it had to do with taxes.
That's what the government argues. And
not unlike TEFRA.
And it's true that it would have amended the Internal Revenue Service, Internal Revenue laws, but the Constitution specifies that bills for raising revenue have to originate in the House, and that bill would not have raised revenue. So although it would have altered the tax laws, and in fact, there's a famous Supreme Court justice named Joseph Story who said that not every bill that touches on taxes has to originate in the House. It's any bill that raises revenue. So a bill that, you know, changed the name of an IRS building or something, I mean, would have something to do with taxes. And I guess every bill has something to do with taxes.
But if this legislation had been something that conservatives generally agree with, I'm guessing that you would not be sitting here right now and you would not be taking this case to the Supreme Court.
And you'd be guessing wrong. I'm not a conservative. I'm a libertarian. And I think that both parties, I'm sure, and I think both parties have abused their constitutional prerogatives and ignored their constitutional limits time and time again.
And you have challenged Republicans on this when?
Oh, sure. We have started. Pacific Legal Foundation was founded in 1973, and we've sued the federal and state governments ever since. So both Republican and Democrat administration.
Interesting. Why go after Obamacare?
Because it's an egregious violation of the Constitution, and many different ways.
Obamacare itself, or just the way that this legislation was passed. Your argument is based on how the legislation was passed.
That's
Are you
right.
asserting that Obamacare itself is unconstitutional?
Yes, because now, one of the things, if the court takes a case, one of the things it'll have to figure out is how much of the law should remain in place if we win. And you'll remember that took an entire day of oral argument the last time, 3 years ago, when the Supreme Court took that first case. And it is a complicated question. So, and I don't know how the court would address that. But our argument is that the individual mandate tax is unconstitutional. And the administration has admitted that if the individual mandate were to be struck down, it would undo the entire system.
But didn't the Supreme Court rule on that?
The Supreme Court never reached that question in the original case. And it is true that if the court were to try and take out a section of the law that was central to how the administration expected it to work, it would be essentially making a new law that nobody voted for or against. And that would probably be too much for the court to be doing.
Yeah, that's judicial activism on steroids.
That was the argument that was made 3 years ago. Is both sides, I think, of the justices were saying, well, we don't want to be refashioning this law into something that Congress never passed.
So you're not dealing with this at the level of policy. In other words, your concern is not what's going to happen to 40 million people who are suddenly not going to have health care if you're successful. Your concern is not the people who are going to die because they can't pay for the medicine that they need if your case is successful. Your concern is purely, is this or is this not consistent with the Constitution?
That's right. That's right. We're not a policy organization to begin with. And if Obamacare is such a good idea, it should be a very simple matter for Congress, after the Supreme Court rules in our favor, to go and repass it the correct way.
Do you think in your wildest imaginations that a Republican Party that is so heavily owned and controlled by the Koch brothers and other billionaire libertarian billionaires would ever do that?
Oh, God, I hope not.
Well, you know that they wouldn't.
Right.
You know that they wouldn't in its current form.
Because there's so much wrong with Obamacare that the American people don't support it now, and they never have supported it.
Actually, a majority of Americans support it right now.
And that's why the Democratic Party sought clever ways to evade the constitutional mechanism for enacting laws in order to avoid an open democratic discussion over the merits of Obamacare. And that's why the American people voted for a candidate who said he was opposed to the individual mandate, and, surprise, got exactly the opposite of what they had hoped. So I think, no, of course not. Of course Congress would not reenact Obamacare. And to be fair to your side, Obamacare is not what the president wanted either. I mean, it's not the plan that he wanted when he proposed it, right?
Don't you think that Alexander Hamilton, in his report on manufacturers in 1793 or 1791, wrote rather extensively about how life, liberty, and the pursuit of happiness, stated not only in the preamble of the Constitution, but also in Article 1, Section 8.
It's not in the Constitution.
Excuse me.
Life, liberty, and the pursuit of happiness.
You're right. It's in the Declaration of Independence. The general welfare. I'm sorry. The general welfare clause, which is stated in the preamble, and it's also restated in Article 1, Section 8. That how could access to health care not be considered general welfare?
Well, to begin with, I'm not a great fan of Alexander Hamilton. I'm a much more of an admirer of Thomas Jefferson, who believed that the federal government needs to be kept to its enumerated powers. The Congress,
he believed that until 1801.
I don't think that's accurate. I think the Constitution specifies what Congress is allowed to do, and the constitutional read on which it has built Obamacare is, it was to regulate commerce among the several states. And
no, the first sentence of Article 1, Section 8 is to do things to enhance the general welfare.
But that is a limitation on those enumerated powers, because if that were the power that specifies, then that would mean that the rest of the Constitution would not have been necessary to write. Congress could just enact whatever it thinks is.
Tim Sandifer, principal attorney. Hey, hang on just a second.
This is the Thom Hartmann Program.
Tim Sandifer, principal attorney with Pacific Legal Foundation, pacificlegal.org. Tim, thanks for dropping by.
Thank you for having me.
Good to see you. We'll be back.